Now that we know what an IEP is, who is eligible, the process of developing an IEP, and who's involved in making the decisions, let's take a look at the court cases, congressional acts, and laws that brought about the introduction of the IEP. In 1954, the U.S. Supreme Court issued a landmark civil rights decision in Brown versus the Board of Education. School children from 4 states argued that segregated public schools were inherently unequal and deprived them of equal protection of the laws. The court unanimously ruled that separate but equal public schools for blacks and whites were unconstitutional. The case served as a catalyst for the modern civil rights movement, inspiring education reform everywhere and forming the legal means of challenging segregation in all areas of society. This now famous legal ruling would have far-reaching implications for the special education arena. After the decision in Brown, parents of children with disabilities began to bring about lawsuits against their school districts for excluding or segregating children with disabilities. The parents argued that by excluding these children, schools were discriminating against the children because of their disabilities. In 1965, the Elementary and Secondary Act, also known as ESEA, was signed into law by Lyndon B. Johnson. The law was designed to address the inequality of educational opportunity for underprivileged children. In 1966, Congress amended the ESEA to include the first federal grant program to help states in the initiation, expansion, and improvement of programs and projects for the education of handicapped children. Title I of the ESEA provides the single largest source of federal funding for public schools today. In addition, Congress established the Bureau of Education for the Handicapped and was later renamed the Office of Special Education Programs. Following the creation of the Bureau of Education for the Handicapped, and based on the precedent set by Brown versus the Board of Education, 2 cases would become the catalyst for the change in education of children with disabilities. The first, in 1972, was Park versus the State of Pennsylvania. In this landmark case, the Pennsylvania Association for Retarded Citizens sued the Commonwealth over a law that gave public schools the authority to prevent free education to children who had reached the age of 8 but had not yet reached the mental age of 5. Prior to the Park decision, children in Pennsylvania could be excluded from public schools if they were determined to be unable to benefit from education. The court ruled that the existing state law restricting kids ages 6 to 21 years of age was unconstitutional and recognized the legal right to public education on the part of handicapped children as guaranteed by the 14th Amendment Equal Protection Clause. The court stated that Pennsylvania was responsible for providing free public education to all children, and that meant that no child, regardless of their disability, could be turned down. In addition, the court ruled that the quality of education given to children with disabilities was to match that of the education given to the general education students.